Chapter 6, Intellectual Property. What is intellectual property? Intellectual property is a term used to describe works of the mind, such as art, books, films, formulas, inventions, music, and processes, that are distinct and owned or created by a single person or group. It is protected through copyright, patent, and trade secret law. Copyright law protects authored works such as art, books, film, and music. Defining and controlling the appropriate level of access to intellectual property are complex tasks. Software has sometimes been treated as the expression of an idea, which can be protected under copyright law. Copyrights. Copyright and patent protection was established through the U.S. Constitution, Article 1, Section 8, Clause 8, which specifies that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. A copyright is the exclusive right to distribute, display, perform, or produce an original work in copies or to prepare derivative works based on the work. Copyright infringement is a violation of the rights secured by the owner of a copyright. Infringement occurs when someone copies a substantial and material part of another's copyrighted work without permission. Copyright term. Copyright law guarantees developers the rights to their works for a certain amount of time. For works created after January 1st, 1978, copyright protection endures for the life of the author plus 70 years. For works created but not published or registered before January 1st, 1978, the term endures for the life of the author plus 70 years, but in no case expires earlier than December 31st, 2004. For works created before 1978 that are still in their original or renewable term of copyright, the total term was extended to 95 years from the date the copyright was originally secured. Eligible works include architecture, art, audiovisual works, choreography, and more. Fair use doctrine. Copyright law tries to strike a balance between protecting an author's right and enabling public access to copyrighted works. It developed over the years as courts worked to maintain that balance. Patents. A patent is a grant of property right issued by the U.S. Patent and Trademark Office to an inventor. A patent permits its owner to exclude the public from making, using, or selling a protected invention, and it allows for legal action against violators. Unlike a copyright, a patent prevents independent creation as well as copying. There are 6 types of patents, with 2 of main concern to information technology firm being utility patent and design patent. Patent infringement, or the violation of the rights secured by the owner of a patent, occurs when someone makes unauthorized use of another's patent. Unlike with copyright infringement, there is no specified dollar amount limitation on the monetary penalty if patent infringement is found. Trade secrets. A trade secret is defined as business information that represents something of economic value, has required effort or cost to develop, has some degree of uniqueness or novelty, is generally unknown to the public, and is kept confidential. There are no time limitations on the protection of trade secrets. There is no need to file an application. Patents can be ruled invalid by the courts. Trade secret protection laws vary greatly from country to country. For example, the Philippines provides no legal protection for trade secrets. In some European countries, pharmaceuticals, methods of medical diagnosis and treatment, and information technology cannot be patented. Coca-Cola reopened its operations in India in 1993 after halting sales for 16 years to protect the secret formula for its soft drink. Currently, intellectual property issues. Plagiarism is the act of stealing someone's ideas or words and passing them off as one's own. The explosion of electronic content and the growth of the web have made it easy to cut and paste paragraphs into terms, papers, and other documents without proper citation or quotation marks. Some students believe that all electronic content is in the public domain, while other students knowingly commit plagiarism either because they feel pressure to achieve a high GPA or because they are too lazy or pressured for time to do original work. A recent survey reported that 55% of university student presidents felt that plagiarism has increased over the past decade, in spite of increased efforts to combat the practice.
Reverse engineering. Reverse engineering is the process of taking something apart in order to understand it, build a copy of it, or improve it. It was originally applied to computer hardware, but is now commonly applied to software as well. One frequent use of reverse engineering for software is to modify an application that ran on one vendor's database so that I can run on another's. Example from Access to Oracle. Database management systems use their own programming language for application development. As a result, organizations that want to change database vendors are faced with rewriting existing applications using the new vendor's database programming language. Courts have ruled in favor of using reverse engineering to enable interoperability. Open source code. Open source code is any program whose source code is made available for use or modification as users or other developers see fit. The basic premise behind open source code is that when many programmers can read, redistribute, and modify a program's code, the software improves. A common use of open source software is to move data from one application to another, and to extract, transform, and load business data into large databases. Some reasons that firms or individual developers create open source code even though they do not receive money for it include: some people share code to earn respect for solving a common problem in an elegant way. Some people have used open source code that was developed by others and felt the need to pay back by helping other developers. A firm may be required to develop a software as part of an agreement to address a client's problem. Competitive intelligence. Competitive intelligence is legally obtained information that is gathered to help a company gain an advantage over its rivals. For example, some companies have employees who monitor the public announcements of property transfers to detect any plant or store expansions of competitors. Competitive intelligence is often integrated into a company's strategic plan and executive decision making. Competitive intelligence is not the same as industrial espionage, which is the use of illegal means to obtain business information not available to the general public. In the United States, industrial espionage is a serious crime that carries heavy penalties. Almost all the data needed for competitive intelligence can be collected from examining published information or interviews, as outlined in the following list: 10K or annual reports, an SC-13D acquisition, 10Q or quarterly reports, press releases, promotional materials, websites. Trademark infringement. A trademark is a logo, package design, phrase, sound, or word that enables a consumer to differentiate one company's products from another's. Consumers often cannot examine goods or services to determine their quality or source, so instead they rely on the labels attached to the products. The Lanham Act of 1946, also known as the Trademark Act, Title 15 of the U.S. Code, defines the use of a trademark, the process for obtaining a trademark from the USPTO, and the penalties associated with trademark infringement. It is not uncommon for an organization that owns a trademark to sue another organization over that use of that trademark in a website or a domain name. Cyber squatting. Companies that want to establish an online presence know that the best way to capitalize on the strengths of their brand names and trademarks is to make the names part of the domain names for their websites. Cyber squatters registered domain names for famous trademarks or company names to which they had no connection, with the hope that the trademark's owner would eventually buy the domain name for a large sum of money. The main tactic organizations use to circumvent cyber squatting is to protect a trademark by registering numerous domain names and variations as soon as the organization knows it wants to develop a web presence. Example, uvxyz.com, uvxyz.org, and uvxyz.info. Registering additional domain names is far less expensive than attempting to force cyber squatters to change or abandon their domain names.